Hello, everyone, and thank you, Bruno, for the kind introduction, and thank you also for supporting us and me, especially in designing and shaping this model. This model that, let me say today, it's I feel very good because it's like having worked for something that it's just building the base, a construction of a confrontation with other stakeholders in order to think about a model. Why do we need a model? So today there's a new inputs and more inputs to continue to do this work of the creation of this model. Our model is definitely based on a target that is unaccompanied migrant children, and it's clearly different than the one that has been treated by our colleagues Nadia and also Georgiana and Anna from the Romanian team. So today I'm going to share with you a presentation. Hopefully it will not be too long. So the first, consider that this model is coming out from the activity research that has been conducted. Can you see the presentation? I hope so.
Yeah,
well,
it's working.
Well, this model is coming out from the research that has been previously conducted by my colleague, Antinea. And the research obviously is based on interviews with prosecutors, judges, and other professionals that are actually in place when we talk about criminal proceedings, especially criminal proceedings where we have children involved also. Clearly, we started our individual assessment model asking ourselves why do we need an individual assessment procedure, and why do we need a model to think of a procedure of assessment? Because simply there are three reasons, and today listening Pippo Costella's presentation and also Alberto's one, we understand that there is there are rules, there are regulations, international regulations and guidelines, but there's still need to implement in practical actions. So individual assessment procedures can offer a chance to have a better protection when we talk about victims, and especially protecting victims from a secondary victimizations. But also individual assessment procedures can be useful when we design and we think about children reintegration. And I think in this case, when we yesterday spoke about the work of the USSM office in promoting projects for the reintegration of children offenders, obviously. But overall, those things, individual assessment procedures could enable a participatory process among all the actors and the stakeholders for the first thing that is called the best interest of the child. Definitely, the individual assessment is towards two main points. One is the individual level, where we see that the child receive a fair treatment, and especially the involvement of the child is considered a priority. And the other direction where we see that individual assessment is a priority is for the system. The justice systems can optimize the resources that he has, and can also, assure a better judicial action in terms of effectiveness also. What is important to remind is that the individual assessment procedure, it's a process that is based already on the standards of human rights and the implementation of human rights as well. So clearly, has been cited and mentioned by my other colleagues before, but the Child Rights Convention is the base, is where we come from in terms of work, and it's the first binding instrument that has been promoted that talks about this multidisciplinary approach or holistic approach. That is actually the things that is common in the three models, and you will see it even later with the presentation of our colleague. When we move from the international legal frame and we go to the European one, we see that speaking of victims and suspect or accused person of having committed a crime, we have two different directives, specifically in terms of individual assessment. The Article 7 of the Directive 800 from 2016 highlights the needs of the child with regard to protection, education, and training and reintegration. And in this case, we are talking about how to work to support reintegration of a suspect or accused person. At the same time, the European Directive and the Article 22 talks about the individual assessment procedures that needs to be carried out when we talk and we deal with victims of a crime. And this stage is particularly important to understand which are vulnerabilities, but also to understand which are the protection needs that the person has. Moving to the best, this model, as I said before, is coming out from the research that has been conducted, but is also coming from an analysis and a research that we have conducted in terms of understanding which are already good instruments and good tools that could be adapted and applied in other contexts. And in designing the model, we thought about the best interest procedure that has been designed and also updated by UNHCR. It is published, and it's a procedure that provides quality standards that can be used primarily in the context of recognition of international protection, but adapting those tools, it's possible also to understand that in the criminal proceedings, there's still a space and a spot to work to improve the multidisciplinary approach. We also took in consideration of the guidelines promoted by the International Working Group on Child Protection, and where we understand that working in a multidisciplinary way in case management, it needs to have an approach that is definitely coordinated. In the Italian context, we see, I'm going a little bit quick on this because yesterday and even today we've been talking about the 448, that it's the presidential decree. I think there's a mistake in the slide, but anyway, we already heard of it. It's the Juvenile Criminal Procedure Code in some way, so-called like this, but even if it was 1988, the Italian legislation provided something that it's, let's say, it has been very important, very interesting in terms of implementation. And I'm referring to the terms of the Article 9 of this code, where we see that the judge and the prosecutors have the power to start the action of individual assessment, and also the importance of the Article 28 of this decree, that it talks about the probation time and the juvenile probation, that it's considered as a good starting point in terms of reintegration. In terms of protection for the victims, in Italy we transposed the European directives, and there's been improvement also in the national legislation. There was a change of the Article 90 of the Criminal Proceeding Code. Why do we need an abstract model of individual assessment, and why do we need it when we talk about criminal proceedings? Before, if I recall correctly, Sebastiano Vinci was talking about the importance of caseworkers and people who take decisions, among other people, to be trained, to be prepared. And that is not only about having judicial knowledge, but it's having analytic knowledge in terms of approaching to the multidisciplinary work that has to be done. Includes also that there's a need to improve other skills. So we think that a model that can also be implemented in the criminal judicial system is a model that is inspired, for example, of the collection of information. Before it was mentioning something like this, that the cartella sociale. People was talking about the importance in the Italian frame of the law number 47. This law is so-called the Zampa law. Zampa is the name of the person who wrote the law. It's very important because it brings new elements in the one that is probably the administrative field work or the immigration field work, but new elements that can be also can find a utilization also in the criminal proceedings. And I'm talking about not only the role of the guardians or the role of the cultural mediator that we will explore later, but one of the first instruments that has been introduced is this cartella sociale. Cartella sociale is nothing else like so could be called a social file. It's a document that doesn't have to be considered as a bureaucratic tool, but has to be considered as an operating tool, well, all the professionals involved in procedures of individual assessment can put their observations and their informations in terms of evaluation of the person. And the main idea of this cartella sociale is not to prepare a document that doesn't have any scope, but it's a document that can follow the child in all his movements. And we know that the reception systems is quite articulated, at least in the Italian scenario. So this document has to have information on the person, but that can be also useful in terms of frame of vulnerabilities and relevant information on cultural, behavioral aspects and other elements really close to the person. The use of this social file is like a tool that can support, for instance, when we talk about secondary victimization, and having already some information about the person can avoid it to stress the person in having multiple interviews and repeating every time the trauma that is always connected to his or her personal story. Our colleague Nadia was mentioning the blue room, that it's another good thing, that it's in some way bring us in common or give us common grounds to work on. Blue rooms, it's a model in terms of where people can, where children can be heard by the judge, by the prosecutor, and by the other professionals. Among other countries, there's the model that is called the Barnhouse model, that it's developed in the Scandinavian countries and spread around Europe and also the United States. The Barnhouse model, it's a model that it's the concept of the one-stop shop, where everyone that has to be involved in an individual assessment proceeding can go to have the interview with the child in a protected and safe environment. In the Italian context, we see that we don't have a specific model on this, but definitely it's important that every person that has to establish a relationship with a child, that has to do an interview with a child and an accompanied child, has to consider a couple of things as important. One is the setting where to conduct the interview. It is important to be sure that there are basic things to ensure that the child feels protected and protected by the different types of elements that can create distractions and can create also ansia. The preparation of the interviewer, it's also another important thing. As Sebastiano was mentioning before, preparation. This is something that it doesn't involve only the aspect of knowledge or being prepared on terms of knowledge of rights and duties, but it means also mentally prepared to afford an interview with a child that has been suffering a trauma. Another aspect that it's important is knowing the child. Interviewing a person is not only fulfilling and trying to achieve the personal goal of the interview, but it's also establishing a relationship with a person and getting to know the child is a priority. Another thing that it's quite important, it's explaining the procedure. And it's important that the one who is in charge of conducting an individual assessment has to explain to the child what is the procedure that is going on and which are the possible outcomes and consequences of the interview. It is of a priority also to maintain a communication that is based on trust, relationship between the person that has to conduct an individual assessment and the child has to be based on trust. And it's also important to remember that when there is an interview with a child, it's like opening a box and trying to bring things outside of the box. But then it's also important to close and to help the person in closing this box. Going back to the point of preparation of the interviewer, we think it's a tool that has to be more implemented in the frame of the criminal justice for child. and it's the use of the COI. It's a tool that has been developed already and pretty much used also in other contexts like the International Protection Recognition Frame. Why it's important to have a knowledge about the other countries, the countries of origins of unaccompanied migrants, because it's basically there's a dimension. Sometimes let's think, for instance, about a case of a young victim of trafficking. There is definitely a dimension of the crime that it's a local one. It's the one that brings the person, that conducts the person to the criminal proceeding. But there's also an international dimension that has to be at least understood by the person who is in charge of the individual assessment. And understanding the general situation of the country means having knowledge about human rights, security situation, political situation, cultural aspects, and other humanitarian information that are relevant in terms of general knowledge about the person. This is a resource that has to be, it can be used by the police, by the prosecutors, by lawyers, by psychologists, and all the other professionals who come in touch with a child. Now we go back to the point of the cultural mediation role. The legge Zampa, the Zampa law, introduced officially this new figure. It's a bridging figure. It's a bridging role between two different contexts, cultural context, and usually the cultural mediator is an interpreter as well, but it's not the interpreter. The cultural mediation is the kind of professional that can just put more close and try to reduce the distance between an unbalanced, let's say, position between the interviewer and the child. And knowledge is not only about language and things that are pretty related to the communication, but it's also related to other aspects more connected to the cultural environment of the person. We think that the role of the cultural mediation has to be further developed in the frame of the community justice system, not only to perform individual assessment, even if we think that it's relevant is its role, but also in other works and other services of the community justice systems. And I'm thinking about restorative justice and access to alternative measures like the probation time and other good ideas in this frame. What we think is also important, and today probably we can confirm this aspect, that there are rules, there are regulations, but we need to strengthen more on the coordination of the actions. The system.
Giuseppe, 1 minute.
Yes, thank you, Bruno. We are talking about a multi-agency or a multidisciplinary system that has to be coordinated, and we think that this role of coordination is definitely in the frame of the system, as Alberto was just suggesting before. It's the system who has to take the responsibility of carrying out individual assessment procedures. And definitely we don't look at the single level, but we look at the individual level, the organizational level, and the systemic level in order to promote a change. I just finished. Thank you for listening. And before closing, definitely we would like to ask questions that you can answer using the poll like before. The question number 1 is, in which terms do you think that the cultural mediator role is relevant during the individual assessment? Is a single choice, and later when the service will show us the exactly. Thank you, Stefano. Question number 2 is, which assessment can be considered relevant to complete an individual assessment procedure? Question number 3 is, does individual assessment procedure apply to your work?